Hello friends, this is Rajeshwari. In my previous video, I discussed Contempt of Courts Act and today I'll be analyzing its provisions. Contempt of courts as defined under the Contempt Act is civil contempt and criminal contempt. Civil contempt is willful disobedience of the orders of the court or breach of any undertaking given to the court. This is necessary power and there are no issues as to civil contempt. It is criminal contempt that has always been in the midst of controversies. Criminal contempt as defined under the Act is publication through any means or doing of any act that scandalizes or lowers the authority of court, that prejudices or interferes in the due process of any judicial proceedings, or it obstructs the administration of justice. Now, the definition, this criminal contempt is challenged on many grounds, but firstly I'll go to subclause 2, that is prejudices. Prejudice means to make biased, to create an unfavorable opinion about the party to a matter. And under this probably falls the media trial. This phrase became popular in the late 20th century, that through the coverage in the newspapers or television, now we have social media also, a presumption, a kind of perception of guilt or innocence is tried to be built about a person. That becomes media trial. And there are some people who support it because they say because other pillars of democracy they have failed. Because of that, media trial is gaining prominence or some legitimacy. There are others who say it is nothing but sensationalization of the news. Courts have also reprimanded media many a times. But because the freedom of press is declared by Supreme Court as implicit in Article 19(1)(a) in the Express newspapers case, and in Siddharth Vashisht's case, Supreme Court tried to make out a distinction between media trial and informative media. Now, court said that when media only informs of the news and views, because under Section 4 of the Contempt Act, fair and accurate reporting of the proceedings is allowed. That's not contempt. So when the media only informs, that is informative media or informative expression. And that's allowed, that is legitimate expression, however unpalatable it might be. But when media tries to pass judgments, it tries to conduct parallel proceedings as to guilt or innocence of the person, and they try to impose their views. They enter into the domain, the judicial premises, and that is not allowed. So that becomes in itself contempt of court. Then we come to scandalizing. We know scandalizing court or obstruction in the administration of justice, these are two vast terms, too vague that they can be interpreted in any manner, and then interpretation is to be done by the courts. So it has been left to the individual judges. They may interpret it liberally, they may interpret it most conservatively. And we have seen that not only the ordinary, the common citizens, even if advocates, they have raised some issues about the judiciary, some suspicions, some doubts about judges, or even about the registry. They have been proceeded against under the contempt laws. And the more depressing is that the courts do not stick even to this definition. When we say scandalizing a court, what is scandalizing? Scandalizing means to speak falsely of somebody with malice, or maliciously of somebody, to make some remark. Malice, or in legal terms, mens rea, the guilty intent, guilty mind, is not an element in contempt proceedings. Though scandalizes requires the malice to be proved, but the courts do not bother to prove the malice, the guilty intention, the mens rea of the contemner. So what happens is, a valid defense a person is deprived of. If you are making a comment with a genuine intention, you want you want some improvement in functioning of the judiciary, you want improvement in registry, or some other reason, very good reason, your comment should be taken positively, because there is no malice. But courts do not follow that rule. Even in 1978, in Malgaonkar's case, the Supreme Court laid down certain guidelines to be followed while deciding a contempt petition. They said if a comment is made in good faith, in public interest, it's fair, it should be treated as not as a contempt, it should be allowed, and then you should see what is the experience or knowledge of the person in the field. Like if an advocate is practising, he's more he's well versed with the functioning. If he's making some comment, that should not be treated as contempt, but that's not followed. Even that rule that was laid by Supreme Court itself, and that is not followed, and that's why it becomes controversial. Now the irony of the matter is that the same Supreme Court, while striking down the Section 66A of the Information Technology Act 2000, that penalized posting of any offensive remarks online, and the Supreme Court struck it down. At the Supreme Court, what it held is that the restrictions on fundamental rights cannot be in an undefined, open-ended, inexactitude and vague language that takes in its sweep protected speech, speech innocent in nature, to have chilling effect on free speech. Now, chilling effect is for fear of some penalization, the speech is suppressed. Now, chilling, libel, chilly is the term that is widely used. Libel and slander, they are the wrongs in law of torts. So now, on the same analogy, how can the such vague and inexactitude definition of criminal contempt be allowed? his opposer. Then Supreme Court, the superior courts have always held that because the Contempt of Courts Act is a restriction, a reasonable restriction on Article 19(1)(a), so we can suppress the speech, free speech. Now, as far as this argument goes, 19(1)(a) does not have only Contempt of Courts Act as a restriction. There are other grounds also on that to restrict the freedom of speech, like security of state, public order, defamation, and so on and so forth. Now, if on any of these grounds a complete gag order is issued, would that be allowed by the Supreme Court, by the superior courts? And then (19)(1)(a) is concerned. That is not the only article, that is not the only fundamental right available to citizens. Article 13 says any law that is inconsistent with or in derogation of the fundamental rights is void. There are other fundamental rights also available to citizens under the Constitution of India. Article 14, Article 21, 19(1)(g), and so on. Is Contempt of Courts Act consistent with these fundamental rights? We firstly go to Article 21. Now, Article 21, it says that no one shall be deprived of his life or personal liberty except according to procedure established by law. And right to life includes right to not just liberty, your right to dignity, right to reputation. And from procedure established by law, Indian courts, they have moved to due process of law. Due process means the law is to be fair, not just the procedural law, but the substantive law. That also is to be fair, non-arbitrary, just. So to deprive, and under the Contempt Act, you incarcerate a person, you hurt his dignity, his reputation, his liberty. Can you do that arbitrarily? So this is another question that needs answer. Then we come to Article 14. Now, Article 14 is, it says that no one shall be denied equality before law and equal protection of laws within the territory of India. Now we know Supreme Court, our superior courts, they have defined, laid down for us the rules what defines democracy, transparency, non-arbitrariness. Huge treatises they have written, produced on the democratic principles, on the constitutional values. Now the same principles and same rules, when we place before the Supreme Court to be applied to the Contempt of Courts law, they just brush it all aside. Why? How is judiciary different from or superior to the other institutions, other democratic institutions created under the Constitution. Not just legislature or executive, there are other constitutional authorities like the Election Commission of India, like the Comptroller and Auditor General of India. They are no less important constitutional authorities. So, how is judiciary different? There should be some intelligible differentia that separates judiciary from other institutions. Is legislature of lesser importance? Legislature, or parliament, that represents the general will, that is constituted by the elected representatives of people. And that, as Supreme Court says, is more powerful because it controls sword and the purse. If its members can be criticized, they can be investigated into by media through sting operations or other means. If any type of information about them is published, if that is allowed in democracy under the Indian Constitution, why not? Why not against the judges? So what the Supreme Court says in matter Hitram Beniwal, Supreme Court said that accusing judges of corruption results in the denigration of the institution and has the effect of lowering the confidence of people in system of administration of justice. If that is the reason, then accusing member parliaments who are the lawmakers or the members of assemblies, accusing them of corruption or any other wrong, would that not amount to denigration of the institution of parliament, the legislature, thereby resulting in the loss of faith of people in the institution of democracy? So on that analogy, if a gag order is issued on media and public not to investigate, not to make any comments against the members of the parliament or the assemblies, what would be left of democracy in this country? Then I come to Article 19.1g. 19.1g is to practice profession. And being an advocate, I'll discuss the rights of an advocate to practice profession. Now, freedom of speech of an advocate within the court, inside the court, before the court, if it is restrained through the Contempt of Courts Act, can an advocate practice? An advocate is to plead, he is to assert, he is to try to convince the bench. And every conduct of an advocate of asserting is not contumacious. But if an advocate would have always this sword of contempt hanging over his head, how can he plead? And on the other hand, the Bar Council of India rules say he must fearlessly uphold the interest of his clients, and he is officer of the court, and if he has any reason during the presentation of a case while otherwise acting in the court, he must conduct himself with dignity and self-respect, and he shall not be servile whenever ground for serious complaint against judicial officer is there it shall be right and duty to submit his grievance to proper authorities. And on that, based on that rule, if an advocate makes a complaint against the judge, he'd be held guilty of contempt of court. We know making some kind of remarks against the registry, a senior advocate had to face the wrath of the court. And you see, there are a host of rules and the Advocates Act, the Bar Council of India rules, Supreme Court, High Court rules. Then the state bar councils, they have their own rules that guide an advocate, what should be his professional conduct and the etiquettes that he is to follow, and to punish him for misconduct. But what about the rights of an advocate? There's only one section, section 30, that says that he has a right to practise in the court. What about his other rights? His right to dignity under Article 21. An advocate may be treated in any manner by the bench. He may be reprimanded, he may be insulted, he may be treated in any improper manner. There is no rule that debars, that prevents the bench from conducting in that manner. What about his right to equality under Article 14? We know the Law Commission, they had recommended that there should be a limit, maximum limit of 2 hours to be assigned to each case, except where some constitutional matter or some issue that requires more time. Despite that, there are some advocates who have a clout. They may consume whole days and the matters are kept on board. The next day also they will be pleading, many a times harping on the same point again and again. They are allowed, while as others, who may be a small advocate, will not be allowed even 5 or 10 minutes. So this is about the right of an advocate. An advocate cannot practice if he is not allowed, if his rights are not protected. That also needs to be debated. And it's not just within the court, even outside the courts. Because an advocate, he is an interested party. As Supreme Court says, bar and bench are the 2 wheels of the chariot. No one can move without the other. If he sees something wrong in the institution and he makes any comment to bring about some reforms, that should be taken positively. But that's not the case. I said, any advocate who has raised voices, he has been dealt with very, very sternly by the court. Less to speak of advocates, even judges, who have spoken against the wrongs within the judiciary. They have been dealt with under the contempt powers. A Patna High Court judge, in a matter before him, he made some comments on the corruption in judiciary in High Court, and then he ordered a CBI inquiry into the allegations of corruption in the subordinate judiciary, and in a swift action, the full bench of the High Court, they debarred him from taking up any matter, withdrew all the matters that were pending before him. Being an insider, a judge knows more. Such complaints should be taken seriously. There should be some proper forum, rather permanent, that takes up such issues. Justice Karnan, I won't appreciate the way he conducted himself after the contempt proceedings were initiated against him by the Supreme Court. he conducted himself in a manner that is totally unbecoming of a judge, and that really brought our institution to disrepute. But going a little back, Justice Karnan was raising certain genuine issues. There was some wrongdoing in the selections process in the subordinate judiciary. He wanted to take up that matter and inquire into that. Then he was leveling some allegations against some judges of corruption. Corruption is not difficult to prove, he said they're living an elite lifestyle. You see the assets, the properties, the foreign trips, the lavish functions and the anniversaries and the weddings. You can very easily prove whether they have disproportionate assets or not. And there were some allegations of moral turpitude, involving moral turpitude against some judges, and they were not all unfounded. Is that some daughter of some lady judge committed suicide because of that? And even Supreme Court says in the Justice Karnan judgment that the allegations are of serious nature which require investigation by some proper agency. If they required investigation, Supreme Court should have ordered that. And secondly, we know impeachment proceedings, they have been initiated against many judges in the Parliament, and inquiry committees have found evidence, though the judges resigned. So I would like, respectfully, with due respects, I would like to know how many times Supreme Court has proceeded against such judges against whom there are allegations of corruption. Bar also raises issues, such concerns, or some moral turpitude. Does that not amount to contempt of court? Now, lastly, because the courts say that their power of contempt is a constitutional power, and so it cannot be anyway limited. I would like to make a comparative study with that of the parliamentary privileges. If there is contempt of court, there is contempt of House of Parliament also. We know Article 105 and 194 of the Constitution of India that confer the powers that confer the privileges and immunities on the members of Parliament and of the state legislative assemblies. And we know the contempt power as well as the privileges we inherited from British 1726 through the mayor's courts. Contempt power were conferred on the Indian courts, and the 1935 Government of India Act. It had the provision for the parliamentary privileges, the privileges of the House. Now, so far as these privileges are concerned, what Supreme Court said in the Kalpana case is that for colonial regime, it's a case of Kalpana Mehta. It said that for colonial, it's a good case on parliamentary privileges. It said that for colonial regime, individuals were subject to law. Constitution of Free India is about empowerment of people. Thus, precepts drawn from colonial past, including parliamentary privileges, must be subjected to nuance that facilitates assertion of rights and access to justice. So we are not to follow what they were under the British. But what happens is, while interpreting, the superior courts have given to themselves more powers than are enjoyed by the British courts, while as they have restrained, restricted, limited the privileges as enjoyed by the Parliament. The British Parliament enjoys absolute powers, but our courts say if any illegality or unconstitutionality occurs, the fundamental rights of the citizens are infringed, we have right to look into the privileges, the legitimacy of the claim of privilege. We have right through judicial review under 32 and 226. And then we know that under Rule 122, it clearly says that the Parliament, it conducts its own proceedings and courts do not have a right. They have no jurisdiction to look into the conduct of the parliamentary proceedings, even if there is some irregularity of procedure. And clause 2 of 122 says that the officers that are entrusted with the conduct of business in the House, they shall not be subject to the jurisdiction of any court. Despite that, a clear provision, and under 118 court makes, the Parliament makes its own rules, and we have conduct of business rules for Lok Sabha and Rajya Sabha. Despite that, courts have made an ingress into the in-house proceedings. The first time they came face to face was in the Keshav Singh's case. It was when UP Assembly passed a resolution directing the two judges of the High Court to present themselves before the bar of the House for committing the contempt of the House, because the court had allowed the habeas corpus petition of a person who was undergoing imprisonment by the warrant issued by the Assembly. And in a swift action, then the court stayed the order of the Assembly. So there was a kind of constitutional crisis, a stalemate. And then at that time the Parliament or the Assemblies could have asserted their power, but they didn't do that. Instead, President of India referred the matter to the Supreme Court again, and in interpreting, Supreme Court gave to itself powers of interpreting Article 194, and also it says that the Supreme Court has right, even if the warrant is issued by Assembly, it has right to look into whether it is just, the warrant issued by the Assembly, the order is just or not. Habeas corpus petitions can be allowed. And then it said that every privilege of the House should be in conformity with the fundamental rights, Article 21, 22 and others. Not just that. Article 191 speaks about the disqualification of members. Clause 1 is about the unsound mind and undischarged, insolvent, similar. In that, it is the President of India or the Governor is the authority. But Article 102, Clause 2 speaks about disqualification of members under 10th schedule of the Constitution. Now, 10th schedule talks about disqualification of members and in that, under the anti-defection law, and in that it's the speaker under para 6a. It is a speaker who is given the power to decide the disqualification. Now, what happens? The para 6 also says that the proceedings under the 10th schedule would be deemed to be proceedings under Article 122 of the Constitution, and that would not be subject to jurisdiction of any court. Still, the courts, the superior courts, they have allowed petitions against the speakers. We have many cases where the courts have gone into the fairness of the judgment of the orders made by the speakers. They say it is a quasi-judicial function that the speakers perform. So, latest we had the Manipur Assembly case, and in that the Supreme Court has gone to the extent of saying that speaker, because he belongs to a particular political party, he cannot be so there is chances of him being biased, so the court should the parliament and the government should see whether speaker should be allowed to exercise their power under 10th schedule, or should there be some other authority, some other body that decides such matters. Not going too far, and they say it is deeming provision. It will deem to be, it creates a fiction. It's no fiction. Even under 10th schedule, the proceedings are conducted in Parliament, and that is protected under 122 otherwise also. And in this Manipur Assembly case also, court directed the speaker to decide the disqualification petitions within 4 weeks, which they cannot under Article 122. So, when it comes to the privileges of the House, of other authorities, the powers, court has also always tried to limit them under the basic feature doctrine, or for violating the fundamental rights, or on so many other grounds, the democratic principles. But when it comes to itself, why they exercise such absolute powers? Why under Article 14 the same principles that the courts have laid down, they do not apply to judiciary? We would see what they said in this Manipur Assembly's case, that the question as to disqualification of member has adjudicated disposition and therefore requires the decision to be rendered in consonance with the scheme for adjudication of disputes. Rule of law has in it firmly entrenched natural justice, of which rule against bias is a necessity concomitant. It is of fundamental importance that justice should not only be done, but should manifestly and undoubtedly be seen to be done. So, on the same analogy, is it not required that the decisions in contempt petitions that are made by the court, being an interested party, they are reviewed by some other authorities, some parliamentary committee? Is it not required that we have some judicial accountability commission? It's not required that judges also act in a more magnanimous manner as the British judges. They have done away with scandalizing contempt. And I'll again refer to that, I'll quote what Privy Council said, that justice is not a cloistered virtue. It also must stand the scrutiny and respectful though outspoken comments of ordinary citizens. It's only when our judiciary shows such magnanimity in taking up the matters of contempt against itself that our judiciary will really improve. We must be open to criticism, because that only brings about reformation. So, with that hope, I end my debate today. Thank you.